Hello guys, and welcome to another episode of my lecture. And on today's episode, we'll be talking about the 3 Nigerian cases that I mentioned in the last video that will be discussed about in this case. So let us get straight to the cases. The first case here is the African Development Corporation versus LEDB and UAC Nigeria Limited. Now, the plaintiff acquired 2 plots leasehold from the first defendant who executed a deed of lease in the plaintiff's favor. Now, the plaintiff's general manager, also a director, signed the deed of surrender on the company's behalf in presence of the accountants with the company's seal affixed. 11 years later, plaintiff sued for declaration that the deed was void because the board of directors hadn't given the general manager the authority to execute such deed. At this point, he should be a guru at this. So what is the ostensible conduct in this case? Whether the general manager can actually affix the company's seal according to the memorandum and articles of association. We do not care if the general manager has been given authority to do so. What we care about is if he in fact has the authority. Do you understand? Whether or not the authority is subject to certain conditions that has not been met is a matter for internal management, subject to the presumption of regularity, which is the non-ostensible conduct, which we don't care about. What we care about is the ostensible conduct. The court held that the defendant was entitled to assume that the plaintiff's company general manager, who was also a director, had authority to execute the deed of surrender. Plaintiff company was therefore bound. Now, we understand what that means. Let's go to the case of Pool House Group versus Continental Bank. The plaintiff company was a customer of the defendant company. To secure an overdraft from the bank of 25,000, the plaintiff executed a deed of mortgage comprising leasehold in favor of the bank. The deed was signed by a director of Lebanese origin, another director, and the secretary, and sealed with the company's seal. The company sought a declaration that the purported mortgage was null and void, in that the director of the Lebanese origin purported to act as a director of the company was an alien and was prohibited under Section 33 of the Immigrations Act 1963 from being a director of the company. Now, the court held that the defendant bank was entitled to assume that the director was properly appointed and had the authority to execute the mortgage on behalf of the plaintiff's company. To a particular extent, I have my personal reservation about this case, because if you go to the case of Royal British Bank versus TURQUAND, the court in that case stated that parties dealing with companies are only bound to read statutes as well as deed of settlement. Deed of settlement, there being articles of association and memorandum. Now, he said they are bound to read statutes and deed of settlement. In this case of Pool House Group versus Continental Bank, a particular statute prohibited Lebanese from being a director of a company. Now, the question is, even if the articles, through its ostensible conduct, authorizes such transaction, can't we say that the statute here, being Section 33 sub 4 of the Immigration Act of 1963, had already barred that particular transaction, since that person cannot act as a director, therefore being constructive notice to the bank as well as any other person entering into a transaction with the company. I want to know what your reservation is on this particular issue, and I would love to also give this as an assignment. So the last case that we'll be talking about today will be the case of TRENCO Nigeria versus African Real Estate Investment, where the Supreme Court held, applying the rule that the defendant was entitled to assume that the chairman of the plaintiff company had the authority to enter into a binding contract with the defendant company on plaintiff's behalf. Now that we are done with this, we understand perfectly what presumption of regularity is, what constructive notice is, what the ostensible conduct is, what the non-ostensible conduct is. Now let us go to the 5 exceptions that we have in relation to this rule. 5 exceptions. So my next video will start with the first. See you in next class.